The prejudice you suffer by undue delay and the prejudice you suffer by lacking the right to cross-examine are qualitatively and jurisprudentially different things.
To present evidence and cross-examine.
Absolutely. To adduce and cross-examine, as the court pleases, my lord. Because the prejudice of not being able to adduce or cross-examine is fatal and final and conclusive. It cannot be redeemed. Whereas the delay, you can find ways to ameliorate and so on. But here, my lord, we are talking about, to put it crudely, witnesses, key witnesses who are dead. That's it. They cannot be resurrected. And therefore, the idea, the very idea, your lordship, as I say, once the matter was using the incorrect test, the lordship then came to the conclusion, which is my next point on the grounds of appeal, that the matter can be determined by the trial court. And here I'm not taking the technical point that this is the trial court anyway. Your lordship meant during the trial. But the point I wish to make, my lord, is that whether it's today, yesterday, next year, 10 years' time, Mr. Tetad will be dead. So he's not going to be more dead when the trial starts. That's it. And we cannot cross-examine a man who's 6 feet under the ground. Today, tomorrow, during the trial, after the trial, and forever. And therefore, that kind of prejudice, I'm simply making the point, my lord, that prejudice is irredeemable and is determinable right now. We don't have to wait for anything which we might discover during the trial. We know already that... and this, my lord, must be tied with the third point and hopefully my last point on the grounds of appeal, which is that nobody, and not even my learned friends, can contest, my lord, the fact that Mr. Tetad is a key witness, pivotal. If there's another big word, I'll ask Mr. Masuku for it. But the point, my lord, is that this case, we must not forget what this case is about. If you walked around in the street, my lord, and asked anybody, what is Mr. Zuma in court for? They're going to say it's the arms deal case. What about the arms deal? Encrypted facts. Everybody knows that. People who don't know all the facts about this case as we do know those two things. The author of the encrypted facts is dead. And unfortunately, that is the sad situation. May his soul rest in peace. But he's gone. And now, if the author of that crucial, that's the smoking gun in this case. The smoking gun is the so-called encrypted facts. If the person who wrote the facts, who says in an affidavit before your lordship, this fact is being misinterpreted. The facts, he says, it is not true that in these facts, encrypted facts, I was soliciting a bribe from Mr. Zuma. He says that. And that statement, he takes to the grave. And your lordship will find that at 496 of the original record. And you see, because these things are glossed over, it's important, to, if your lordship allows me, just to read from the facts. Mr. Tetad wrote the facts on the affidavit, after he had, remember there was another affidavit where he had agreed to the authorship of the yes. Then he says, in his other affidavit, I was bothered by the fact that I had to do this cryptic affidavit that simply says I'm the author. And I kept on bothering the people until they said, okay, do the one where you want to explain. And he did. And this is what he says. At this stage, paragraph 4, I wish to state that I do not agree with the interpretation according to Annexure X, that's the encrypted facts, by the state. Furthermore, the state seeks to draw inferences from Annexure X which are not justified. It says, during and before the meeting I allegedly had with Mr. Sheikh, I was allegedly requested by him to arrange payment of a bribe by Thompson CSF to the Deputy President, Mr. Zuma. And then he says at paragraph 6, in response to the above, I wish to state 1. At no stage did Mr. Sheikh ever request from me or in my presence the payment of a bribe to the Deputy President. I'm jumping to the next important one. The document Annexure H was never, to my knowledge or on my instruction, typed or faxed. And then it says it was merely a rough draft of a document in which I intended to record my thoughts on a separate issues in a manner which was not only disjointed but also lacked circumspection. And then that's the gist, my lord. In other words, the author of the encrypted facts and this affidavit says it is not what the state says it says. Now, of course, your lordship knows sufficiently that that is the stuff cross-examination is made of. If Mr. Tetad was in the box right now, has a right to call him to adduce his evidence to support his case. But we have a bigger right, my lord, to cross-examine him. Because, as your lordship knows, we have a right, the right to cross-examine even a co-accused. Both of those rights, in respect of Thales and ourselves, to adduce and to cross-examine, are contained in Section 35(3)(I), and both of them are gone forever. So the notion that this is an interlocutory application and all that is really just baseless. To crown it all, my lord, and I don't want to repeat the submissions eloquently made by Mr. Roux, what the state, and by the way, my lord, we also agree with your lordship on the Section 6 point. I'm glad, I thought it was going to be another fight between me and Mr. Roux, but fortunately he also agrees that your lordship was correct in terms of Section 6. But with the greatest respect, that does not absolve the court from its responsibility to look into the matter in terms of 172(1)(b). Because even Mr. Roux's prayer in terms of Section 6 could be construed in terms of the wide powers that the court has in Section 172(1)(b). But I'll leave that aside. Let me make this final point on the merits. So what is the answer of the state? It says, well, the lawyers are available. And the lordship, once again, correctly finds that on the issue of availability, there is a dispute of fact. And that dispute must be dealt with in terms of the Plascon-Evans case. No quibbles with that. Where we quibble with your lordship's finding is the second leg of that, which then says that that evidence may or may not be admissible. Because Mr. Roux is right. That evidence is, as we sit here, inadmissible. Or at the very least, they have the absolute legal privilege. But even if they didn't have a legal privilege, it's so speculative. That is speculative. How do we know? What did they say when they consulted with Mr. Tetad? What if, did he deny? Did he confess? We don't know. If he did, will they, if they say, well, he confessed or he denied, then what? How do we cross-examine them on that? So the right to cross-examination, even if your lordship is correct on their availability, is still curtailed because it's limited, let me put it that way. And when a right is limited or even threatened in terms of Section 38, then the court must declare that the right has been infringed. So, my lord, whichever way you look at it, just on those, I don't want to go into other issues, just on those 4 grounds, there is no doubt that there's a reasonable prospect that another court would find differently. And said, or I don't even want to go to the Makate leg, which we have pleaded in our heads, my lord. And that's a crucial point, my lord, that, of course, your lordship, again, your lordship cannot be blamed for this, because your lordship gave this judgment in June. And then on the 31st of July, the Constitutional Court gave the decision in Makate. And the crux of the, I'm sure academics are having a field day about it, but in my respectful submission, the crux of the Vodacom Makate case, my lord, is to open a new avenue for appeal. So we have Section 17A1, Roman 1, Roman 2, and Makate. Because Makate says, in essence, paraphrased, and this is very important, irrespective of the correctness or otherwise of the judgment. And that's very crucial. So that means it negates Section 17A1. It says irrespective of whether there's reasonable prospects and all those things, put that aside. Once the court has failed what the Madlanga J defined as the right to adequate consideration of a point put before it, then that judgment must be set aside. And with the greatest respect, my lord, we respectfully submit that this judgment, if we are correct, of course, on the D and I issue, then this court has, with the greatest respect, failed the adequate consideration test set in Makate, in the sense that the court adequately considered the 35.3D, but did not consider 35.3I. And my lord, I can get the ZACC of Makate. I'll give your lordship the reference. No. Can you get the ZACC reference? Oh, it's in our heads, my lord. We've referred to it in our heads. Yes, Makate, I'll just get it from our heads. Yeah. And this is at paragraph 63, my lord, of Makate versus Vodacom. This is what Madlanga ADCJ said. The adequacy of reasons, let's start at 62. Whether a court's reasons are adequate will depend on the nature of the case, the issues, and the ambit of the evidence and submissions. The test is not perfection, but adequacy. Adequate reasons do not necessarily have to be lengthy, as we know, my lord. Then I'll jump to 63. This is the crucial part. The adequacy of reasons is not concerned with whether the reasons are sound, correct, but whether they sufficiently explain how the court reached its ultimate conclusion. The reasons must be responsive to the case, live issues, and the parties' key arguments. The more complex and extensive the evidence and arguments, the more extensive will the reasons normally need to be in order to meet the test of adequacy. The reasons must be such as to enable the losing party to see that the court has decided the case that was argued and understand why that party lost. Reasons must also be such as to enable an appellate court to follow the court's reasoning with a view of assessing whether it was right or wrong. Reasons must disclose the path of reasoning. And to close that chapter, my lord, our respectful submission, if we are correct that the court was, as you say, waylaid, and therefore did not deal with the case before it, then the Makate test as well as the other tests have not been met. Then, my Lord, if I may, then jump to the second application. And again, Your Lordship will forgive me if I jump back to the application for leave to appeal in order, for purposes of illustration.